You're welcome back. This is Newsfile, your most authoritative news analysis show, and is brought to you by Bank of Africa, strong as a group and close as a partner. Also brought to you by MTN. Welcome to the new world. Sasso spray that is fresh and powerful. Star Assurance, they've been creating smiles since 1985, celebrating 30 years of solid partnership. Lipton Tea, the #1 tea brand. Yum Vita, the delicious way to grow. And it's interesting. I just read a portion of Sabetically Speaking. It's a book, Sabetically Speaking. It's a book by Nana Erred, and he's a chemist, and he does it so well with satire and gets all of us to reflect, look into ourselves in the mirror, and ask ourselves if we're being worthy sons and daughters of this country of ours. And I just read a portion of it to do my introduction, and I've got thoughts of my friends sending in messages asking me to read that portion again because they want to hear it clearly. I read it. It's very short as my guests are settling in and getting ready. Now, I read page 34 and page 35, just portions of page 34 and 35. And this is what Nana Erred says. He's a satirist. And he says, have you realized how often we patch the damaged portions of the motorway? And we do this with chips and bitumen on a concrete road. Common sense would dictate that if a concrete road is damaged, you cordon it off, excavate and recast to repair it. Of course, this takes time and more effort. For years, we have continued to repeat a process that only lasts for a few months. Just recently, I saw workers on the motorway still doing this. Is that not how we have treated our economy? With solutions that are at best misfit patches, without going to the root causes and repairing for long-term effects. Remember the repair on the concrete bridge, which we did with steel. Earlier this year, the steel plates is showing us its toothy smile as I write. And then the last bit I read is here, where he says that one of the reasons we have been giving for the inability to maintain the motorways streetlights is that the cables have been stolen. Yet we have police patrols 24/7 on that stretch. And we have citizens traversing it all the time. Under our very noses, in the same way, our national coffers are emptied and both officials and citizens say nothing. We are happy to continue sinking funds. Sinking fund sounds like the name of a particular fund as far as the budget is concerned. It says we are happy to continue sinking funds into laying more cables to feed the criminal industry, just as we continue to pump money into areas of our economy where hitherto we have had massive corruption. Just as we drive on the bumpy motorway, the nation plods on. And this book was launched just yesterday by Professor H. Kwesi Prempeh, and it was a launch that was very heavily attended by people that I have a lot of respect for. And I want to say thank you to all of you who came in there. You can look for copies at Amazon. You can look for copies elsewhere in this country. And when you do, please also get a copy for a friend. Like Kofi Bento did yesterday. He packed like how many? About 10 copies, he alone. And he's going to share with his friends. Let us read some of these to ourselves and reflect and ask ourselves if we're being worthy citizens of this country, because it doesn't look like we are doing the best of service to this country at all. Thank you very much. Now, I've got my guests getting ready and taking their seats. Once I introduce my guest, Abdul Malik Kwekubaku. He's editor-in-chief of the New Crusading Guide newspaper. He's a regular panelist. Kuku, good morning and welcome to Newsfile. Dr. Jumaima Nunu, you have asked us to bring her back. Right, she's right here for you. She's going to dish it out. so you'll enjoy as you did the last time. Dr. Jemima Nunu is a lecturer, business school at GIMPA. Good morning and welcome, Doc.
Good morning.
Thank you very much for joining us. Also in the studio is Nana Akomia. He is Director of Communications of the New Patriotic Party, whose woes are never going away. Every day they have stories to share. Now on suspension spree, and the NDC also seem to have taken a cue. They're also beginning to suspend their MPs and people who have won primaries to contest elections. Nana, good morning.
Morning, Samson.
Right. I was asking the question in my introduction. Baumia says this government is trying to fix this economy with propaganda. But was he not up to propaganda? Sebi.
Sebi means what?
Sebi.
Okay.
Yeah.
Thank you. Let me wish your listeners. I always forget it's a television.
Yes, it's television viewers.
Viewers and listeners a good Saturday. Yes, what Baumia, Alaji Baumia, he just returned from Mecca.
Right.
What he said is 100% correct. That the government of the NDC has been running largely on propaganda. There's no doubt about it.
Okay, we'll get to that. I just wanted to see if you confirm or not, but why did I expect that you would not confirm? Okay, now we want to start with the issue that has to do with some bit of our money that we can lay our hands on, over 3 million Ghana cedis. It appears to be slipping, away from us, but since we are able to take hold of that and, push it back into the COFEX, let's try and get that money and put it safely where it belongs before we continue with all the other issues at large. But before we start with that, and I'm talking about the GMPC ex-gratia payments, is it dubious or is legitimate? The GMPC issued a statement and said that, quote, they had a valid obligation to make those payments. Well, it does appear that their lawyers advised them that making the payments were illegal, unlawful, and they ignored that. Well, there are calls that the president, if he didn't know about it, should sack the board. But before we start with that issue, our preliminary issue we are looking at this morning, about just 2 minutes each from my guest, because what we do on Newsfile is that when the court gives a judgment, we want to have the judgment itself, read it, thoroughly, analyze it before we discuss it. We don't have the judgment as far as the Dua Jaho issue is concerned, so we'll do just preliminary comments. I see if 2-3 minutes each will be okay. Now, Kuku, start with the Dua Jaho issue. And the Supreme Court says he was wrong. Simply put, he violated the constitutional injunction. Or, beyond the constitutional injunction, you have the case of Asare versus Attorney General in 2003-2004, in which the Supreme Court said, without any equivocation, that when the Vice President and the President are both out of the jurisdiction of this country, someone ought to step in because they are unable to perform their functions. And the Constitution says, before you do so, Article 61 is it, before you do so, you ought to take and subscribe to the oath of office. Dua Jaho twice. In the course of last year, is it? Yes, he was sworn in once to take the stead of the president, the vice president. The second time he was supposed to be sworn in, he declined and protested that he wouldn't do it too many times. Now Samuel Atta Mensah, who is the manager of City FM, went to court and he was victorious, declared by the Supreme Court on Thursday that Dua Jaho was wrong. I must say kudos to the lawyers who led it, Ni Apatu Planche, Clement Akapami, and Chris Oseyeboa, as well as Yao Opong, who is always on the show. Kuku, what do you say? There are those whose problem is that by Article 2 going or so, if you disobey the directions or orders of the Supreme Court, you are a subject for what is called high crime. and you could go into jail for up to 10 years. And after that, you will not be able, you are disqualified from public office or for elections for another 10 years. People are wondering that they expected that this should happen, and it didn't happen.
That would have been really, really a dramatic point in our history. You know, you have indicated here, we don't have the full benefit of the judgment.
Right.
So one is not sure how to go about it. I also really do not know the kind of advocacy that was pursued in the proceedings by the plaintiffs and their lawyers in terms of what they were seeking and all those things. But that aside, we recall that this became a matter of huge public interest. I think this program discussed it a couple of times. And I remember you yourself writing a certain piece on it. And when I made my comment to the effect that what had happened, based on the initial reports we had, amounted to constitutional lawlessness, I was viciously attacked by somebody on Ghana Web to the effect that an illiterate and ignoramus like me ought not to discuss such matters. You know, it was a vicious attack. He asked for my certificate and all those things, and thought that when lawyers are talking, somebody like me should not be given the opportunity to articulate my views, as if illiterates don't have the right to expression. Whatever it is, in substance, the Supreme Court judgment appears to have vindicated the line some of us took.
Right.
So I hope that gentleman is listening to us. But the key point, you see, Justice Annan, I've been going through the Hansard, and I realized that Justice Annan acted 4 times as president. The first 2, he took the oath. On the 3rd and 4th, he did not. More or less making it look as if was vindicating what Ajao did recently. If you recall that when Ajao's thing came up, he made a statement, I think on the floor of the House, it's captured in the Hansard, that it was after consultation with the Chief Justice and the leadership of the House that they had arrived at that decision. Some members insisted on getting the particulars, better and further particulars, which were not provided. So safely, I would rather put the entire onus or the responsibility on the Speaker, because we don't, in the absence of anything of evidential value, to back the fact that the Chief Justice, because the Chief Justice was at the House, if you recall.
Yes, she was.
Yes, she must have been there for a reason, I think, to administer the oath, in my candid opinion. So it is the Speaker that we hold responsible. It's a clear violation of the Constitution. I would repeat, constitutional lawlessness of a sort. What now is being pushed forward is the question of sanctions, whether or not the Supreme Court should have gone to the extent of prescribing sanctions.
Right.
Obviously, if they did, I'm sure it would have been part of the news reports.
Right.
So I'm assuming safely they did not.
They did not do so. And our understanding, but from the lawyers, is that it was pressed for that he ought to be punished that way. But the suggestion was that the Asari versus Attorney General case, in which the Supreme Court pronounced that when the president and the vice president are both outside of the country, it means they are unable to perform their duties, and the Speaker should step in, did not speak specifically about making a direction that you should take and subscribe to the oath. The law says if you disobey the orders and directions of the Supreme Court, it is a high crime. So can we say that he disobeyed the orders and directions of the Supreme Court?
No.
When the Asari case, it did not say make an order that you should subscribe to the oath.
Then that brings some clarity to the issue. If that's exactly what the legal position is, then it means that going forward, it's when anybody who does what Ajao did may be caught in the net. That's what it is. This is what my layman, illiterate view, understanding of what you've put out there means.
Okay.
You know, so maybe we should be looking at the going forward more than trying to go back and insist on a certain retroactive action in this sense.
Right. And on this show, part of what we do is also educate the generality of the public about the things you have concerns about. Many people have been asking that, is it because he's Doa Jahu, the speaker, that's why the Supreme Court did not punish him? Because if he had been an ordinary citizen, he would have been punished. And you hear people making comments, people steal goats, they steal mobile phones, and they get jailed for so long. And someone disobeys the Constitution, and he's left, you know, without any punishment. Nana, when the issue happened initially, this is part of what I said, quote, that's November 7, 2014. I said, I, as a citizen of this country who respects the laws, will not obey any orders or directions emanating from the Speaker that are taken in the name of the presidency. I would rather obey a lawful instruction from the Chief of Staff. I was taking on and also dealt with like who claims, but it looks like there's a vindication. He violated the Constitution.
Well, something the Supreme Court has ruled, so we have to abide by it and do what the Supreme Court has ruled on.
Let me say welcome to Felix Kwachi Ofosu.
The rule here today is that no propaganda.
He's a Deputy Communications Minister.
Now,
I'm watching you. When you do propaganda, I can tell.
Now, like I said, the court has ruled, and all of us must go by it. I have a difficulty with the ruling in terms of the practicality of it. Kukubakun talked about Justice Annan having done it twice, and then probably got tired of it and neglected to do it the last 2 times. Peter Lajete must have done it about 4 or 5 times. I remember on one occasion, Parliament was summoned at midnight.
That's right.
Midnight. So that Peter Lajete can take 3 minutes to recite the presidential oath. I think it's absurd. This provision in the Constitution is absurd. The Vice President, he takes the oath once, doesn't he? And he remains Vice President. He acts when the President is not in for 4 years. There's no worry.
He's not exactly the Speaker. Or the
no, I'm saying that, but he's not the President. But he takes the oath once. Why can't we just let the Speaker?
He's President, except that he's Vice.
He's not President.
He's President.
No.
He's Vice.
He's not President. He's not President. He's Vice President.
Deputy Minister. He's a minister.
No. He has to take another oath. This man is here. When he becomes a minister, he has to take another oath. But I'm saying that for the practicality, going forward, we need to maybe change the wording and stipulate that the Speaker has to take the oath once and reword the provision so that once suffices for the 4 years. Because it's absurd. I mean, when you have there was a situation where the President was out, the Vice President was out, then the oath was taken, the President came in 2 days later, and then a couple of hours later he flew out. So the Vice President, the Speaker takes the oath, then it goes out in 2 days, and then another 2-3 hours he has to take the oath again. I mean, practically, is absurd. It's absurd. So now that is what we have. But going forward, taking a cue from the situation that it applies to the Vice President, I think we have to look at how we can reword the Constitution
Felix
so that we avoid this.
But the argument has always been, there's a good number that says this is actually a needless exercise. We don't need it. Because particularly in the times that we find ourselves, if we're in the Stone Age, that's fine. But now, in any case, wherever the president is, he's president of the Republic of Ghana. So to say he's unable to perform his functions is also absurd, because wherever he is, he'll be performing, or whatever he'll be doing it for and on behalf of the state Ghana.
Absolutely, and something I'm on all fours with Nanakumi on this one. That provision in our Constitution is clearly anachronistic. Perhaps at the time that the Constitution was being framed, it appeared a good measure to ensure that there's some continuity and that there's no, if you like, vacuum at all created in terms of the exercise of executive authority. But in this day and age, it is not necessary at all. The Speaker was of the view that having taken the oath a couple of weeks
he did it
earlier,
yeah.
It was not necessary to do it again. So he felt that it was superfluous and that we could get on with running the country.
But it shouldn't be about his feeling. It appears
no,
he was advised.
It was a matter of legal opinion, really. And mind you, the Speaker is also a lawyer of some.
No, but to get to the point where even the CJ, the Chief Justice, was invited to the House to come and do the function.
Yes.
And for the Speaker to decide that she should go away.
The Speaker preferred the legal opinion. I recall that on the floor of Parliament, he gave reasons why he thought that it was not necessary. Somebody tested it in court, and the Supreme Court has done what they are there to do anyway: interpret laws and provide clarity.
He put these people to a needless exercise.
Well, that is why the Supreme Court exists. Wherever there are gaps in terms of agreement or disagreements in the way that the Constitution ought to be applied and interpreted, they come in. They've given a ruling. It will bring clarity and finality, unless, of course, that ruling is reviewed.
So what it is, like Kuku said, is that next time, if you are supposed to take over and you don't subscribe to the oath, you are in violation of the order of the Supreme Court.
That is what it means.
And you suffer as many as 10 years in prison, and after that, you are disqualified from public office for about 10 years again.
But even that punishment is very dramatic, like Kuku said. But that is what it is at this moment, until and unless the decision is reviewed. But going forward, we must do something about that provision because it is not necessary at all. It does not reflect our current interests. Yes.
Yeah. Doc, what do you say? There are those who are saying that this Supreme Court should have taken the advantage of the new, this recent decision to go back and change its old decision, which said that if the president is not around and the vice is not around, still someone ought to be sworn in.
I mean, to be honest with you, I mean, I kind of understand. I understand that opinion because I do feel it's a little superfluous, and I do feel that, you know, I mean, the provision is there. The president is the president of Ghana wherever he goes. The Supreme Court has ruled. Now we know that moving forward, an oath has to be sworn, but I do think it needs to be reviewed. I do. I think it needs to be reviewed and. Again, as Nana Komia said, we have to look at the practicalities of these things. Yeah, there's the law, the legal rulings, etc. But we need to look at how it's going to be implemented or operationalized. And sometimes these things are not the most practical. So I think I think it should be looked at again. I think it should be looked at again.
Okay.
I think the Constitutional Review Commission made a recommendation to the effect that the Speaker should be deemed as having...
Exactly. And also we should find a way of prohibiting the President and Vice President to all be absent from the country at the same time.
That's in Mozambique.
But something, with the greatest of respect, I think that is not necessary, really, for somebody else to take over the work of the president merely because he's outside the jurisdiction. We have all agreed here.
We're coming from a history.
I agree, but we have all agreed. I understand that, but we have all agreed here that wherever the president is, he can perform his functions. There are institutions of state.
Assuming without admitting, in a very unlikely scenario, the president is caught up in a terrorist zone as a captive of terrorists. He cannot.
But that would be a peculiar situation, which we can address when we get there.
And when you need to declare war.
But I'm sure, I'm sure the Constitution itself has a cure. The Constitution says if the president is indisposed or incapable of performing his functions, something ought to be done about it.
That's where the vice president comes in.
Exactly.
But if the vice and the president are both out. For whatever reason.
And all of them are devastated.
Those who are involved in this case, some of them have sent me a few messages. This one from Professor Kuku Asari. Sending us from the United States, where he is. He says that we canvass the view that it was high crime because Ajaho himself had acted twice when Speaker Bamford Addo acted as president. The president had written the CJ twice. The CJ had shown up in Parliament twice, and Parliament itself had been convened twice. Thus, the order in Asari versus Attorney General was known and understood by the Speaker. However, I believe it is time to amend the Constitution to wash the original sin of Dateba in the initial Asari case. And the sin he's talking about is where you say, you know, there's a need for someone to take over, or the fact that he's unable to perform his functions. Both the AG and I asked the court to examine the wisdom of the decision, even though we differed on the implications of such examination. Okay, so this is where people say the Supreme Court should have taken an advantage of this particular case and have made a ruling that it's really not, you are not unable to perform your functions by dint of your absence physically from the country as president. And then one of the lawyers also sent me this, that's Ni Apatu Planch. He, together with Clementa Kapam, started the case initially. And then they got joined by Sosei Yeboah and Yao Opong. Now, he says, the court said that the Supreme Court was not the right forum for that criminality of the violation. The jurisdiction that was invoked was interpretation. The court addressed that bit and said that the Speaker is the head of the legislature. When he was crossing to assume and perform the functions of president, he has to swear he only performs the functions of the president.
That's an interesting point.
Yeah. So thank you very much. So if it is a criminal and someone else has to trigger it, then will the Attorney General do it? That's interesting, isn't it? All of this taking us into a certain, situation. I don't think the Attorney General would like to start criminal prosecutions against the Speaker of Parliament. Now, shall we deal with GMPC and the issues that are arising? I'm sure that you are quite familiar with them, Doc.
Yeah.
That we're told that Chachichi Kata and also his partner, Esther Koba, one former chief executive, Mr. Safoye, and then one other officer of the GMPC who had left the GMPC over a decade ago, were due certain payments. And the board, in its wisdom, decided that it was going to compensate them. Some were getting about a million Ghana cedis. Some were getting about 600,000 Ghana cedis. Esther Koba has issued a statement that, yes, she's been informed that this money was on its way, but it hasn't come to her yet. And she insists that she's owed a significant amount, which ought to be paid her, including her Provident Fund, accruals. And then GMPC also issues a statement to confirm that, yes, we did actually do this, and we feel that they deserve it. Parliament also summoned them to justify this, and we understand that they had a difficulty. And in fact, it became obvious, or it became known, that even GMPC's lawyers had advised against the payments, and the board went ahead. So far, only one person, we are told, has received his check. On the basis of these developments, Parliament has deferred, we are told, dealing with GMPC's, their program of, activities for the year.
Okay. I mean, this whole issue, for me, I was initially very confused because I was trying to make head or tail of what was going on. And I think still, after doing my own little bits of research, I'm still confused. And there's a number of questions I think it raises. I think, first of all, I'm still confused as to what kind of a payment it is. Because if you read their statement, initially it talks about an ex-gratia payment, which you referred to.
Right.
And then later on, talk about an end-of-service payment. And they're two distinct things. They're not the same. So even in that statement alone, it's ambiguous. It's not clear to me. So if it's an end-of-service benefit, ESB, then those are decided beforehand. Those are legal. When you get your contract, I know my end-of-service benefits where I am. Mm-hmm. And so that should be really easy to establish, whether it's an end-of-service payment, which you're legally obliged to give, because at the end of the day, it's part of the contract that they've signed, or is it an ex-gratia, which is a different beast? So I need that to be cleared for me.
There's a policy that's freezing ESBs.
That's why we need to know what it is. So is it an ESB or is it an ex-gratia? Because, as I said, it's ambiguous. Also, my other question is, why now? Yes? Since, I think, 2000, and we're now in 2015, there's been about 3 or 4 different GMPC boards. And I don't know, was it discussed previously why 15 years down the line it's been decided now that actually we need to make these payments? Does this board have, I don't know, some kind of evidence, something that has suddenly cropped up? That's why they feel that the payment must be made now. And also as well, I mean, I know that the GNPC budget, it's a GMPC, as we know, is a publicly owned company, so the budget has to be approved by Parliament, yeah? So if the budget has to be approved by Parliament, was this captured in their 2015 budget? Were these payments captured there? If not, why not? And if not, then where are they going to get the money from? Where is the money coming from for this approval? So I don't know, I think I'm confused, as you can tell. I've got lots and lots of questions that I think need to be answered. I think that, you know, it's good that we probe these issues, because it just seems to me that, you know, the payment has been made. It doesn't seem very clear as to how they reached this decision and why they reached this decision. And I don't know if anyone else can shed light, but as a regular person.
The statement they issued was that these are individuals who contributed significantly to the development of that entity, and they were deserving. And the entity felt there was a valid obligation, and I'm quoting the valid obligation.
Is that a legal valid obligation or a moral valid obligation?
Well, you have made the difference. You have distinguished between ex-gratia and ESB, and you have said that ESB ought to be paid upon law or upon your contract, and ex-gratia is not. It's only some sort of a moral, you know, obligation, apart from Article 71 office holders.
Yes, so that's what we need to know. And I think that these questions need to be answered. So it's good that Parliament probe it. So yeah, I need answers.
Okay, now let's hear Kweku.
See,
Kweku is taking in a deep breath,
yes,
and he's got newspaper clips of
this
19...
one. No, this is courtesy my friend Egbert Faber. He actually gave this to me only last 2 or 3 days.
Okay.
It's December 2nd, 2000, Daily Graphic. Chikata made energy advisor. 3 other changes announced, and it's to the effect that the President, Flight Lieutenant J.J. Rawlings, has appointed Mr. Chasushi Kata advisor on energy with immediate effect. A statement issued in Accra yesterday from the President's office said he has been replaced by Nana Boakye Asafo-Adjei as the Chief Executive of the Ghana National Petroleum Corporation in the interim. Of course, this was 2nd December 2000. Within the matter of 20-something days, the NDC administration, that's the number 2, had lost an election, and the NPP assumed office in 2001. One would be wondering, in the period between 2001 and 2009, what Mr. Chikata might have done relative to his benefits, call them ex-gratia or ESB. I will go with the definition that she's made. It's quite correct. What were the attempts? I'm saying so because today's Daily Graphic, my Daily Guide, there is this publication to the effect that Alhaji Sogro, who is the head of the Mines and Energy Committee, has disclosed that the minister, the present deputy minister, Dagadu, is the one who is received, the only one who is received payment. He's received 1 million cedis. And Amalaba makes an interesting point that point about law and limitations, the statute bar thing, applies to only people who slept on their rights. And then the 6 years really means nothing. I find that a bit of a dubious validity. But since I'm an illiterate and shouldn't be talking law, I have to proceed on the note of caution.
The law is written in plain, everyday English.
I've been cautioned.
That's what Professor V.C. R.A.C. Crap has now done to all our laws.
Yes.
So read it. The limitation decree is very clear.
So you admit that interpretation by brother Amaliban might be of dubious validity.
I'm unable to agree with him.
Thank you. Well, you are being charitable. You don't want to accept my description, but it's still the same thing. But you see, so we're asking, even if he's a member of the board.
Yes, he is.
Yeah, that's why I'm putting premium on it. So if indeed Mr. Chikata did not sleep on his rights under the Kufuor administration, where is the evidence? And not just Mr. Chikata, but all the others, especially the wife, Madam Esther Koba. We must see some evidence. If after pursuing it administratively, it didn't work, did they opt to go beyond the administrative framework, in this case to institute some legal action to get their benefits? But I agreed. I recall the PNDC abolished ESBs in the early 90s. I don't know what happened to companies, entities on their own, the kind of collective agreements they had. That is another area we should look at. But you see, the point being made that some have not yet received their monies, and so then Katie Hammond perhaps jumped the gun. I think it's a very disingenuous observation to make. There was a policy out there. The policy decision taken by the GMPC board was cut in iron, and that's why one person has received. Okay, that's why one of the recipients, beneficiaries, has received his. So we need to question the rationale that went into that policy. It's critical. And I'm happy Parliament has intervened, because then the documentations, the records must come. Call it ESB, call it ex-gratia. What is the thinking that went into that? Is it that the invaluable services they performed rendered to GMPC and the nation? What is that? What does it constitute? What kind of animal is that? Okay, let's do a surgical analysis and find out, even if there is no legal basis, whether there's even a moral one. I think this particular issue is clear-cut. You know, I would take on the GMPC board for it. There's no basis. I'm preempting parliamentary investigations in this sense. Clear in my mind that there's no basis. I've done some checks. The checks I've done to show that the chief executives, as well as the members of the board, the management of the post-Chachu time, those under Kufuor's administration, have not been beneficiaries of this particular policy. So then there may be some lack of equity, because they also contributed services, invaluable services. Indeed, the oil discovery was done under some of them, their watch. Okay, so if we want equity, if we want fairness, then that policy, even if it's outside the framework of ex-gratia and ESB, because when you read the thing about valid obligation, invaluable services, I'm getting the idea that we are not talking of ESB or ex-gratia. Somebody has sat down and decided that, look, these people did so well for us, we found oil, GMPC is doing well, let's recognize their contributions. That's outside both frameworks. That's the way I see it. Okay. If so, then others may qualify. If others have not qualified, have not been listed and have not been, listed as beneficiaries, then clearly you might be thinking of political, some chronism in this sense.
But what is the effect of the Saturday, December 2nd, 2000 Daily Graphic report that you make reference to, which was headlined Chikata made energy advisor, three other changes announced, and it says that the President, Flight Lieutenant J.J. Rawlings, has appointed Mr. Chikata advisor on energy with immediate effect. What does that mean to the whole situation if it were to be an ESB or ex-gratia?
No, even at that point in time, assuming December 2nd, I'm sure he still would have been entitled to some benefits relative to his tenure as CEO of GMPC. I'm not a lawyer, but this is the way I'm looking at it commonsensically. But once he transited to the energy advisor, some hybrid factor comes in. Okay.
Why hybrid? The entity that received him where he was, the entity where he worked at his last place, that was the one supposed to cater for him.
No,
that's what it's
political. I see the energy thing more as a political appointment. The energy advisor. assuming he had been there for long, assuming they hadn't lost the elections, and he had continued as an energy advisor and ended, he would have been entitled to some ex-gratia as a political appointee, wouldn't he have been?
Yes.
Yes, and that's what I mean is that he would have had 2 levels. And there are many examples, make no mistake, from the PNDC era to now. People were political appointees, collected their ex-gratia, moved to statutory corporations and things, and benefited as well, double toed. And I'm saying that in that situation, is if they hadn't lost the election, and even if they had lost, but he slept on his rights for as long as the 15 years, then I'm saying that thing is lost. It's gone. It's a lost opportunity.
Right. But Felix, and it ought to be put in this perspective that the issue of the limitation decree, that it's a statute barred. After 6 years, you cannot go and claim any longer. The law simply says these things, for example, actions founded on thought other than actions which not necessary for this purpose, actions founded on simple contract, actions founded on quasi-contract, actions to enforce a recognizance, action to enforce an award where arbitration and so on and so forth. Particularly when you're talking about here, you're talking about actions founded on, a contract. Now, the suggestion is that after 6 years, he would not have been able to go to court to demand this. But it ought to be clarified that it does not mean that if the entity didn't pay attention to this, it was not allowed to go ahead and pay.
Well, I mean, you have clarified. You are the lawyer. I'm
right.
Not. So first of all, let me clarify the 2nd December bit. Yeah, Mr. Chikata was removed as chief executive, or like managing director of GMPC, and made energy advisor. But he was on secondment. So he was still the employee of GMPC.
No.
That was the arrangement, yes.
No.
That is the arrangement that...
No, not at all.
Well, where you get
that he was... But the statement didn't even say that he was seconded.
Yes, but he was not
factual.
No, but if you are removed as managing director, it doesn't mean that you are not an employee. He was second, and there are instances today of persons who were appointed by the president. An example is Sam George. Sam George is a presidential staffer, but he's on secondment to the Ministry of Communications.
Okay.
So there's no ambiguity about that. That must be made clear. The second point is that when K.T. Amon first raised the issue, and perhaps it is because of the way that K.T. Amon himself approaches these subjects, he created the impression that the 4 individuals concerned had done nothing and the board had approved monies for them. Essentially, they were giving money for doing nothing. And we all know the sensitivities around the issues of ex-gratia payments. I mean, earlier to say that Mr. K.T. Amon himself has benefited from 2 ex-gratia payments.
He described this as a criminal payment.
How can it be criminal? How can it be criminal? Mr. Chikata, since 1988 or so, has been at the helm, or was at the helm, of GMPC until December 2000, when he was removed and seconded to the Ministry of Energy as an advisor. That appointment ended in August 2001. That was the date that it was terminated. Now, Mr. Chikata and the rest of them, Mr. Asafweje, Madam Mr. Koba, who has a long-standing relationship with GMPC, which we all know, and Mr. Dagadu, were entitled to be paid. Indeed, in 2002, there were a number of GMPC employees, some of whom I know, whose appointments were terminated, for whom these payments were made. Indeed, it would have been expected that these 4 individuals would be added to the list and paid, but they were left out. So it is important that we discuss these matters carefully. An impression is being created that because it is Strategic Kata, he does not deserve it. Of course, there's a parliamentary inquiry, and GMPC has indicated that on Monday, they will furnish the appropriate documentation to the committee so that they would examine what the board did and see that it is above board. But we have to remove emotions from this discussion. The way that K.T. Amon presented the matter sought to create the impression that, well, the strategic Kata, so some payment was being made to him illegal. That is what he did.
Yeah, but the principle is the principle. K.T. Amon is bitter. He has a grudge with Chikata and,
but that cannot, your government. That cannot hold sway.
And your government. No, and that is one of the reasons his major interest was to bring this to the fore to deflate attention.
Oh, of course, but
because at the moment he is also
the subject of some inquiry.
Well, he's in court. He's in court.
Fine, so it's okay. He's fighting to clear his name, but that process will go on. But whether he has a grudge with Chachu or government or not is immaterial in this matter. We must stick to the facts the way that he put out that information was unfair.
But that information was first put out in August.
No,
by
but
the
it was
news
Ketia who
station.
resurrected it. But Ketia Amon is the one who has spoken to it forcefully. He says that it is criminal. What is the basis for saying that it is criminal?
It's illegal.
What is the
According to
basis
legal
for saying that it
advice.
is criminal? Especially when evidence exists of payments to other former employees of GNPC.
Kweku says pay attention to the illegality of it because GMPC's lawyers advised the corporation that it was illegal.
We were all in this country. We saw what happened to Mr. Chikata under the Kufuor administration. There's a man who was so harassed to the extent that one time he was chased to church to be arrested.
Okay.
And what circumstances was he? No, you see, you cannot. You see, I'm going to
for
speak.
whatever value that
you see,
this
I've raised that to show you.
Right.
That the environment within which Mr. Chikata operated at the time could not have lent itself to the pursuit of these payments.
How?
But if the board
went to court over 10 times.
But something, you tell me.
He went to court many times.
This is a man who on multiple occasions was arraigned before court. Eventually he was jailed in 2008, if I'm not mistaken.
Yeah, so he was eventually pardoned.
Exactly. So it was not as though this is a man who had his peace of mind, was walking about the streets
what's
and
the
failed.
point? The point I'm making because he was harassed.
Subsequently,
because he was harassed, he could not have made his legitimate demands of the government.
But the circumstances were clearly not conducive.
But he was in court fighting for his rights on many levels.
In any event, there's evidence of demands that Mr. Chikata made in the post-MPP era, indicating that he was entitled to these payments. And there was a back and forth.
And he went to court.
Whether he went to court or not, for me, is immaterial. The point is that
these demands were made in post-MPP era.
Of course. I have already set a context, a framework, and told you that the MPP government was certainly not going to pay Mr. Chikata any entitlements. In any event, in 2002, let them be denied that in 2002 they did not make payments to a number of GMPC extras whose appointments they had terminated. They made payments to them. So the MPP government was not in principle against the payment of these monies, except that they left out 4 people. So the question ought to be posed, why they left out these individuals when the company has a tradition of making these payments.
And the lawyers advised the entity that after 6 years, when the demands have not been made or the payment has not been made,
that is a matter that is subject to further scrutiny. I have told you that the parliamentary inquiry will go on and all these matters will come to the fore. But the point that some seek to make, that this is an isolated approval made by the board for the purposes of giving Mr. Chikata and others money they do not deserve, is not valid at this moment. There's evidence of payment to other staff. I don't think that it is fair to have left out these gentlemen and then come back later and say that if the board finds that an error was made in the past and they seek to correct it, some wrong had been done. The other point is that these are people who worked with the organization. They were not outsiders who were simply put from somewhere and the board made a decision to give monies to. That point must also be clearly established. But the full facts will unravel when GMPC finally appears before the parliamentary inquiry, where the platform will be created for further analysis to be carried out on this matter.
Yeah, Nana, let's hear you. I suspect the NPP will be organizing a press conference on this one.
Well, it's about the people of Ghana and the monies that belong to the people of Ghana, not the NPP, not the NDC. Now, the impression should not be created that Honorable K.T. Hammond just went on some emotional binge. No. K.T. Hammond was very clear, and we should be congratulating him for bringing this issue to the fore. We should be, until it's proven wrong. Because this clearly is an issue that has to do with the use of public monies. He speaks in a certain way. I mean, all of us cannot speak the same way. But he was not emotional at all. He was very clear-cut. He had possession of the facts that he was speaking to. And it's generated a lot of public interest and debate to the extent that Parliament is seized on the matter. And all of that is due to the work that K.T. Hammond has done. Now, the impression should also not be created that these payments were not done because there was some persecution of Mr. Chachu Chikata. Because it is not only Mr. Chachu Chikata. There are at least 3 or 4 people involved. So even if somebody didn't like Chachu Chikata, how about the rest? Understand there's some gentleman called Dagadu or something?
Yes.
And then there's a Mrs.
Current deputy minister.
I don't know. So it is not about Chachu Chikata. It's about 4 or 5 individuals. So the impression should not be that there was some dislike for Chachuchika, that there was some persecution, and that is why his entitlements were not paid. It is not true. It cannot be true. Now, it's been put out there that there's a legal opinion from inside GNPC that the payments would be illegal. Is it true that that legal opinion is there?
Yeah.
Yes, that legal opinion is there. So inside GNPC itself, there was no consensus on the matter. And even whether it is ESB or whether it's ex-gratia has not been clarified. And also the calculation.
For that, we stick to ex-gratia because that is what the GMPC's own letter says.
So ex-gratia,
yeah.
The calculation, is there some formula that has to be followed, or is just people sitting down and deciding?
According to section 10.3 of the GMPC law, when you terminate and people are due their payments, it ought to be 6 months of their salaries or 6 months emoluments in lieu of 6 months notice.
Yes, is that ESB or ex-gratia? Because I suspect what you are talking about is the ESB.
That is so.
Now, so if GNPC has stated that this is ex-gratia, then we need to know the basis. Because what is provided for in the conditions of service that you referred to would be ESB, end of service benefits, not ex-gratia. So we need to know what discretionary considerations went into the amounts. Because the public interest also largely stems from the quantum of the payments that have been made. And also,
there are those who are saying the calculation has been done using the current salary of the chief executive, which is about 40,000 Ghana cedis a month.
Incredible. Absolutely
so
incredible.
That's what was used. That's what we are told.
Well, they have to
matter worse.
They have to go and justify why they believe that that should be the basis of their calculation. But the bit about, the people have done some work for GNPC, and so they deserve it.
That is one dispute.
Yes, but like Kweku said, other people have also done work for GNPC. Have they, especially those under whose tenure the oil was actually discovered? Have they also been paid? Their entitlements?
Have been paid.
And also, what I find curious about this whole thing, assuming Mr. Chikata and the other lady and gentleman were entitled to something, and because of political considerations, which cannot be true, because it's not just Mr. Chikata. There are about 3 or 4 other people there who, I don't know if they also have some political interest to anybody. But what is of interest to me is that, assuming the previous government neglected to do this thing, how come that it's taking 7 years? Assuming Mr. Chikata or the other gentlemen were even fighting for these payments, and they were not successful because of the political regime. Assuming so, how come it's taking 7 years? Was somebody else not paying because of political considerations? Especially when you look at some of the actors involved in this decision, you would find out that they've been quite close associates of Mr. Chikata. So those are the issues, and I'm very happy that the parliamentary committee has been seized of the matter, and they are holding an inquiry. The inquiry should be thoroughgoing, and at the end of the day, we would see if public monies have been used judiciously or not.
Jemima wants to say something, but before she does, what do you make of this questioning by Professor Kweku? He says, without doubt, the approved payments are most unusual as they amount to a retrospective modification of an executed labor contract, a violation of the ESB's freeze policy in existence since 1991, and a highly questionable, perhaps fraudulent payment of ex-gratia. Under Section 5.4 of the GMPC Act, PNDC Law 64, quote, the remuneration of members of the board shall be determined by the president on the advice of the minister, unquote. He asked the question, did the president determine this unusual remuneration? If the president determines this remuneration, If he determined this the remuneration, then he has to explain its basis. If he did not, then he has to hold the board accountable for usurping his powers under Section 5(4) of the law.
Yes, I mean, Mr. Azar, Kweku Azar is somebody who's had profound legal knowledge, and I'm sure these issues will play at the parliamentary committee during the inquiry.
Felix, are there legitimate questions for you? That the president is the one who determines the emolument, or so to speak, the remuneration of the board. Was he aware? If he was aware, he should explain. Yes, if he was, yes, if he was aware, he should explain to us. If he was not aware, then he should sanction the board.
Question to this particular discussion. We are not talking about the board's remuneration or emoluments. We are talking about the ex-gratia or ESB or whatever you choose to call it for 4 former employees of GMPC. If he questions that, he would have a basis to do so because he is a Ghanaian. But like I have indicated, there's a formal inquiry into the matter. The people who made the decision are going to face Parliament, and they will provide the various answers.
This is an incurably bad decision.
Well, it is only an opinion you've expressed.
Yeah, I'm entitled to
the decision is not only bad, but it's incurable.
But the board is also entitled to explain what they did. Until that explanation comes, I think we should hold our horses.
Yes. Okay. I'm glad you say so.
Well, there are citizens who are already contemplating some action in court. I don't know what basis they are looking at. Yes, Doc.
No, I mean, I think it's good that we try and discuss these things dispassionately and not, cloud the judgment. Anyway, I wanted to ask you a question, Samson, because I want to know the difference between an illegality and criminality. Yes, I don't know. Yes, so if somebody says something is criminal, and someone says something is illegal, what's the difference?
Okay, it could be illegal, but does not come with a criminal sanction, so to speak, as in take a fine from you or put you in prison. It could be illegal, and the way to deal with it is by a civil action and not a criminal action.
Okay.
But in this case, if they've paid some monies, would we be moving towards willfully causing financial loss?
Yes, that's what I wanted to ask.
That's what some people are raising already. Right. Criminality, the law is very clear. I think Article 12 or so thereabout, it says 11, 12 thereabout, that something is not a crime unless it has been specifically mentioned by law, prohibited, prescribed, and then the sanction has also been prescribed for it. Okay, this is where we take a quick break. We'll return to share with you the text messages that have come in as far as this issue is concerned, and Doa Jaho's matter also is concerned. And then we'll move on to Baumia and how he assesses President Mahamad's incompetence, rather competence. You see how he deals with it. Was he dealing in propaganda whilst accusing the government of being propagandist with the economy?